State has agreed to recommend to the court costs only, but I don't have to follow that if I think that this was serious enough. Do you understand that?
Yes, ma'am.
I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am.
Are you admitting here today you in fact did operate a motor vehicle on a highway or roadway of this county and state, taking control of your life and control of your path and control of the demon of alcohol? That your driving privileges were revoked and you knew they were revoked. Do you have any questions for the court or for Mr. Schmidt before I proceed? I was in a meeting and it went a bit long.
No worries.
Okay. Let me see. Mr. DeRoy, you can come on up here, please. Just have a seat right up there. We will go on the record in the matter 26 CT07, State of Wisconsin versus Kenneth DeRoy. The state appears through District Attorney Kevin Schmidt in person. Mr. DeRoy appears in person with his counsel, Daniel Chapman, by video conferencing. We're set for a status conference. Mr. Chapman, can you please update the court?
Your Honor, I have the discovery and an offer. I believe this matter will be resolved. Mr. DeRoy is currently in the intoxicated driver intervention program. We're going to need to wait until he's completed with that, and he will need to sit 48 hours in the jail when it's resolved. I'd ask that it be set for a plea and sentencing in about 2 months. I believe that should be sufficient time to get everything set up.
All right. Mr. DeRoy, are you employed?
Yes.
Do you work Monday through Friday?
Yes.
You work, what hours do you work?
6 to 3.
6 to 3?
Yes.
So 3 p.m.?
Yes.
All right. Where do you work?
Webster School District at the schools.
Okay. So if you're done at 3, would you be able to be here and ready for a plea and sentencing, knowing that you're going to go into custody immediately for the weekend? I'll do it on a Friday if that works better. We can do it after work. And then you would be released in the morning on Monday. So does a Friday work better after 3?
That would work fine, yes.
Mr. Chapman, I could do Friday the 25th, and we can do on September 25th at 3, or no, 3:30.
Yes.
All right. I usually don't try and schedule things so late in the afternoon on Friday, so I can do some work and do whatever, but I'm A-okay doing this so it helps your life better.
Thank
You're
you.
doing the IDIP program, so be expected, and your attorney will tell you if this is exactly a plea. It's going to be set as a plea and sentencing, but you will need to immediately go to jail. And again, you won't be released until Monday morning when they can put you on the monitor if the court grants you that ability. Okay.
Okay.
All right. So we'll see you Friday, September 25th at 3:30.
Okay.
Okay. Come on up and get your notice. We are adjourned, but Mr. DeRoy, you will be late on that Monday. So I would probably tell him you wouldn't be able to work until noon or so. Or you can take the whole day off if they'll let you. All right, thank you. Mr. Mason? On the record in the matter 26 CM48, State of Wisconsin versus Cody Mason. The state appears through District Attorney Kevin Schmidt in person. Mr. Mason appears in person with his counsel, Joel Feliski. We're set today in this matter for an initial appearance. However, Mr. Feliski, are you aware of 26 CF 100, which has just been filed recently?
Thank you, Your Honor. I was notified this morning of that new filing. I did discuss that with Mr. Mason. I've also had a very brief opportunity to discuss that with the state. And based on that conversation with the state, it is my understanding that this new filing would impact any potential resolution we may be able to reach in this case. In addition to that, Your Honor, I've had an opportunity to review the discovery in this case. I've discussed that with Mr. Mason. Based on that review and discussion, I would like to look into a potential reverse other acts motion for this case. So I'm asking for another status conference in order to discuss terms with the state and look into that motion issue.
Okay, and that's for this misdemeanor case?
Correct.
With this felony case, can we just move his initial appearance from September 9th to now, and we can just join these cases?
I would not necessarily have an objection. I do not have a complaint available for me
I
at this
sure
time.
can print one out for you.
I
so
would
you can
gladly
go
take
over
one.
It with Mr. Mason.
Absolutely.
And I so appreciate your thorough investigation and negotiation with the state on the other matter. It's going to print over here. You can come over here and get the complaint, briefly read it, or read it as long as you need to, and then discuss it with Mr. Mason, okay?
Of course, Your Honor.
While we are briefly off the record, Ms. Kirsch, thank you so much for filling in today. I so appreciate it, and I appreciate your services.
Of course, no problem.
All right, back on the record, some appearances as previously noted. Mr. Feliski, were you able to go over that criminal complaint with Mr. Mason?
That is correct, Your Honor. I have reviewed the criminal complaints, including the charges and the maximum penalties with Mr. Mason. I do believe he understands them. We will waive formal reading, enter in pleas of not guilty as to counts 3 and 4, and would request a preliminary hearing on counts 1 and 2 within time limits.
All right, thank you. Not guilty will be entered as it relates to the both of those misdemeanors. You still live on Ellis Avenue?
No.
Did you say within time limits?
Yes, Your Honor.
It's going to be very difficult. It's most likely going to have to be in front of Commissioner. And so you won't be able to argue any evidentiary issue or motion on that day. Boom, boom, boom. I just can't do it. Commissioner's not here. gonna have to, you should see my calendar. I'm double, triple booked on all the days. I'm out of county all day on the 21st. I can't do that, and Friday, and Mr. Schmidt, we're gonna have to miss some of our DJC meeting. That's all I can cut. And that would be Thursday, July 23rd. And we could do 9:45 and cut into my meeting.
Take a moment to discuss this with Mr. Mason. Your Honor, I do see, looking at my calendar, I have a preliminary hearing in Polk County at that time. Discussing this with Mr. Mason, Your Honor, he's indicated that he would not object to having time limits waived for the preliminary hearing.
Mr. Mason, I really appreciate that. Thank you. And then perhaps maybe at that time, if you're able to get your other acts motion done, we could probably do both in the same time. So
ma'am.
that actually probably works out better.
Certainly, Your
How
Honor.
long do you think you're going to need to get your other acts?
Some of this is going to depend on my investigator. Unfortunately, I think looking at what we would have to produce, it would probably take me about a month.
And I would need time too, because I usually respond to other acts with a written one. And if they filed one, I would likely file one as well.
I am totally okay with giving all of the time. I just want to make sure that, because he wanted a preliminary hearing within time limits, that he is really okay with going that far out, because we're gonna have to go to September.
I'm fine with that.
What?
I sound fine with that.
Okay. And can you just make sure that the
Sorry.
microphone is closer? It's just because, as you can see over here, I have a virtual court reporter here today, and she really needs to be able to hear everything and get it all down. All right?
Understood.
Okay. What about having the hearing September 11th? But how long do you think it's going to take for this other acts? It's not going to be too long. It shouldn't take too.
No, I think a month would be appropriate.
Yeah, but how much in time of a day? Like an hour?
Oh,
half
I
hour?
think at most an hour.
Mr. Schmidt, what about you? Do you think it would be about an hour?
It's not an evidentiary motion, so I don't even know why we do oral argument, to be honest.
Well, we're gonna have the hearing and we're gonna have a prelim, so we're gonna have the date and do the things. I can do September 11th, anytime between 9 and 10. And I guess we'll just set it for 15 minutes.
I think that'd be appropriate, Your Honor. I have full availability anytime in that framework will work.
Why don't we schedule it for 9:30 and we'll just block off a half hour just in case.
That will work.
Because if it's gonna be a prelim, it might be a little bit longer than that allotted time, but we'll see. So September 11th at 9:30, okay?
Understood.
You can come up here and get your notice. So this is off the record, but, so you're gonna need a month to file it. You're gonna file it in a month, correct?
Yes, Your Honor.
And so,
I mean, he's saying he needs to do investigation. Maybe we should wait for him to figure out he does have another acts motion.
well, okay. I'm just saying that just because I want to give timelines, if that does happen, so that you know when to file it by, and you
Certainly.
know when to file your response. If there is one, okay. If there's not one, that's okay too. As long as you're okay with, we're still going out that far.
I understand, Your Honor.
And
Fine.
if by chance there isn't another axe motion that you find after your investigation and all of those things, and Mr. Mason and yourself, you would like to have a prelim earlier, because I could squeeze a prelim in earlier than September, but maybe. I don't know. It's pretty booked.
I'll notify the court as soon as I have reason to believe that would be appropriate.
So let's just give you a deadline and then I'll put that stuff on the record, but let's just say August 15th is your deadline. Do you think that's enough time for an investigation?
I think that would be appropriate. I think that'll be enough time.
Okay, so August 15th, we'll give you as a deadline. And if there is one and something's filed, Mr. Schmidt. Well, August 15th is a Saturday, so the 14th, I guess, will be the day. So I'll write that down. So I say it, August 14 deadline. And then Mr. Schmidt, do you think you can have yours done by the 28th?
August.
Yeah.
I can.
Oh, wait, did I look at the wrong one? No, I was in, okay. You think you can get it by August 28th? That's 2 weeks.
I'm promising something. I don't know if I'm gonna file it because I haven't looked into
I
it.
know, I'm just saying, just in case. Usually you get things done, I'm gonna say lickety split really quick. So,
I'll put a note, August 28th deadline for other acts.
I'm gonna
response.
say this on the record and then, our clerk will, Olivia, will get it in the minutes, okay?
My main concern with your deadline is I thought your investigator was leaving. So like, I don't know how you're gonna do an investigation in a month.
Well, we've got Craig up in Superior, but that's best I can do.
Okay.
Okay. And if you need more time, something, just let me know too, and we'll figure it out.
Of course, Your Honor.
Back on the record, same appearances as previously noted. Off-record discussions with both attorneys as it relates to any evidentiary, any other acts motion and the preliminary hearing and timelines, et cetera. The court has ordered a deadline for August 14th for Mr. Flisky to be able to file his motion if one exists. After he investigates, he determines he needs to file that motion. And the court did give a deadline to the state for August 28th for any response to the motion. And then Mr. Flisky, you would have until September 4th if you want to reply.
Yes, Your Honor.
However, if something comes up because of your investigator situation, and if you need more time, and if Mr. Mason is okay with it, we can extend those deadlines and extend that hearing date. And if you discover that you did not come up with the information to file another acts motion, then we can attempt to get an earlier preliminary hearing.
I understand, Your Honor.
All right. Let me just verify Mr. Mason's information so that I know. Are you still at P.O. Box 134?
Yes.
He said yes. And your telephone number ends in 0365?
No.
6197?
No.
May I get a new one, please?
715-553-1004.
He said 715-553-1004 for
Yes.
the record. All right, maybe send you text messages?
Yes.
Okay, thank you. We will. Anything further?
No, Your Honor.
State.
Okay, then we are adjourned. Thank you. Yep. You can take all the time you need. Vicky, Miss Bauer, sorry, Miss Bauer. You look very nice today. Oh, thank you. Mr. Naine. We're not going to go right away. We just need a little bit of time so my clerk can catch up.
Excuse me.
We will go on the record in the matter 24 CT 60 State of Wisconsin versus Devin Naine. The state appears through District Attorney Kevin Schmidt in person. Mr. Naine appears in person without counsel. We're set here today in this matter for a status conference. Mr. Naine, you were in the process of getting your license. You've done some things. How close are you to getting your license?
As of 6 months ago, I was forced to relocate from outside of town here to Rice Lake. I was fortunate enough to get an apartment as well as a co-signer for said
Can you
apartment.
just make sure that the microphone is a little bit more towards you? It's just so my court reporter can make sure that she gets everything, just like turn a little bit to your, like right to your mouth. Thank you.
Do I need to repeat the last?
I think she got it. We're good.
Okay, anyway, I was forced to move. I got an apartment in Rice Lake. I did have a job, but my employer decided to sell or post their business for sale, and since I was the newest hire, they, unfortunately, yes,
Okay,
I do have multiple apps out now. I had a call back from Rice Lake Weighing.
that's
Monday.
great. That's grand. That's wonderful. What I asked is, how close are you to getting your license? What steps do you need to do?
Due to what I said previously, none. I was handed the paperwork for the Barron County driving assessment, stuff like that, since that's where I'm located now. I was trying to look for it on my own time, but the lady out front handed it to me before I came in, all the information that I need to move forward in my current location.
One of the clerks?
Yes, ma'am.
That would be Amy. Probably she's amazing at doing these kinds of things.
Okay.
Okay, so you know what you need to do? And are you gonna have the money to do it?
The fees are a lot steeper down there from what the paper has shown, along with my rent.
Breathe in the microphone, just talk in the, I'm sorry, it's just, I need my court reporter to
I
be able to
understand.
understand.
It's possible, yes, it may take more time now that I have a rent to pay.
All right, so here's the deal. You have $694 posted in this case because you missed court, bench
Yep,
was
the-
issued, you have $500. You need to give me all of that information. I'm setting a hearing, a status conference, very short turnaround. I don't care if you appear by telephone or by Zoom, just like my court reporter is doing here today. I just need an update. Here's the deal. I want you to get your license. Mr. Schmidt wants you to get your license. The offer is do what you need to do, get your license, and the matter will be dismissed completely, okay? Or you can plead to the charge for costs. And here's your options. You can plead to that charge right now, and I'll do it here today if that's what you want to do for costs. You have enough posted, you'll probably even get more money back. So if you want to take that part of the offer, that offer part, you can. Or you can say, you know what, Judge, I want to get all of the information I need. I want to know how much it's going to cost, the steps I need to take, and how long you need to tell me how long it's going to take you to get your license. And what the court would be willing to do there is if you say it and show me proof, it costs $300 to take this assessment and only at $100 to do whatever. I will divert or ask that money to be sent directly to those places, not giving it to you, directly to those places so that that money can be used for those purposes. I just want to make sure that this case is going to be resolved timely. It's 158 days. I'm not too concerned about that. It's not too long, too old. So those are your options, okay? You can plead to the charge for costs, be done here today. You'll get money back. You can have a status conference in a couple weeks. I don't care if you appear by telephone or Zoom, and you update me exactly of what you need to do. And somehow you provide me proof of, here's the document. It says $380. Please divert this or send this money to Barron County Driving Assessment Program or whatever it is. Okay, so those are your options. Is this your wife who's here with you today?
No, ma'am, that is my mother.
Well, your mother looks great.
Thank you.
So, all right. So what I can do right now is take a brief little recess, allow you to go talk to your mom, have some conversations, come back. You can update me on what you want to do. Again, we can resolve it today, be done, and you'll get money back, or we can continue down that path. Okay. In a second, we're going to go off the record. Your question is not going to be on the record, but you can ask me a question. So please project your voice.
So if we were to resolve today and it goes away,
Yes.
say 2 years down the road, we wants to get his license back, is in a better place financially, whatever. Is this going to come back?
Nope.
Or,
Nope. He just has to do what he needs to do. This may cause a little bit more of a delay in the DMV to give him the license. I don't know exactly how that, but if it's 2 years and it's been 2 years, that shouldn't be a problem. If it's gonna take him 2 years to get his license, and you guys fully know that, you think he just needs to be in a better place, he needs to be more stable, and you're good with driving him wherever he needs to go.
he kind of lives with.
I live-
with most things.
Okay.
So,
So, yes, after, whatever, Mr. Smith, you can answer a question too if you want.
The two things that could affect his license is if he has an unpaid fine, they could use that to suspend his license. If he already has that paid and she's fully resolving the fine, that can't possibly happen. The second thing is when you get certain tickets, like in this in Wisconsin, you get points against your license. Points expire after a year. So if the plan is to do it more than a year out, the points would have already expired.
So those are your options. What I'm gonna do, I'm just gonna have you guys just go talk outside, talk amongst yourselves. Let me know. We'll figure it out. Okay?
Very well. Thank you.
Ms. Campion, Mr. Chanel, can you hear me?
Yes.
And I don't think I'm gonna need Mr. Chanel to do any speaking, but Mr. Chanel, you're kind of coming across a little quiet, but I don't think I'm gonna need you to speak probably because I'm gonna talk to you, Ms. Campion. We will go on the record in the matter 26 CF 12, State of Wisconsin versus Richard Chanel Jr. The state appears through District Attorney Kevin Schmidt in person. Mr. Chanel appears by video conferencing, as does his counsel, Emma Campion, approved by the court. We're set today in this matter for a status conference. Ms. Campion, can you please update the court?
Thank you, Your Honor. We received new discovery on, hang on one second. I think I have a sound issue on my end. My apologies. We
Okay.
received new discovery on Monday that I think is in impact negotiations. I have not had a chance to talk to the state about it. So I'd ask for an adjournment, and one more status conference. I don't think we'll need much time. I think 2 weeks, 3 weeks is fine. But because of the new information that came in on Monday, I'm not prepared to tell the court, unfortunately.
Basically, lab came back with unusual results.
Interesting. I can't, I don't get to hear or see those things, but I don't like to hear about them. Okay, so you're saying, do you really, really want a status back on the record, or we are in the record, I think, do you really, really want a status in 2 weeks, or do you want something a little later is okay? What
A little
exactly
later
are
is
you looking for?
fine. I don't have a problem with pushing it out. If the court and the state were concerned about progress, I'm fine to have it sooner, but we can push it too. I'm not super particular.
Ms. Campion, I fully trust that you're doing your job. I fully trust that you are negotiating and working with the state as you can as a defense attorney. I'm not too concerned. How about August 13th? And we can do I can probably squeeze you in anytime in the morning.
If it's Zoom, that should work. I could do probably anytime after 10:30, or I could do 9. I have a 9:30 pretrial block in St. Clair County that likely will take an hour.
I could do 9. It's just gonna be a quick little hearing. I have another one scheduled at 9, but that's gonna be quick too. And I can do yours first if you need to make sure you can skedaddle, and Zoom is fine.
That works for me then.
And Zoom's fine for you too, Mr. Chanel, okay?
Yes, ma'am.
Okay, see, I really can't hear you though, so I don't know if I need you to speak, you're gonna need to be in a different way in Zoom, or just call with your telephone.
Sorry about that.
Now I
Oh,
can
that's
hear.
much better. That's much better. Okay, thank you. So we'll see you August 13th, 9 a.m., okay?
Sounds
Yes.
good. Thank you.
Thank you.
All right, thank you. We're adjourned. Back on the record, same appearances as previously noted, 24 CT 60, State of Wisconsin versus Devin Naine. Mr. Naine, please update the court. What is it that you're looking at trying to do?
I have agreed to nip this today.
Nip it in the butt
Today.
today and get her
Today.
done.
Yes, I did have a question. Since we are going that route, and I understand that some money may come back, whatever. Later on down the road, as was mentioned earlier, 2 or 3 years when I'm in a better place, would I still have to do the AODA assessment?
Yes,
Yes, okay,
you will always have to do those.
right, okay.
Otherwise, you will not get your license. So you can
Just
take,
clarify.
let's just say it's taking you 3 years and but you are finally stable. You have your rent paid, you have your house, you have money to buy a car and all of those things. Yes, you will still need to do that
Right, just at that time.
at that time.
Perfect, okay, yes, exactly.
Technically, you are ordered to do that at the time of the OWI, but that's what they're gonna say.
Right.
Because they're gonna say, you have to do this, this is what you have to do, you do it, and you can get your license, all right?
Absolutely,
So you wish to accept the offer of plead to the charge for costs?
yes,
Okay. Now, Mr. Naine, how old are you?
27,
Can you read, write, and understand the English language?
yes, ma'am.
Any drugs, alcohol, or other medications that you've had today?
Not for a long time.
Not for a long time?
I'm still sober from alcohol since the last time I saw you.
I'm so proud of you.
Yes,
That
ma'am.
really is excellent. How many days have you been sober?
I lost count. It's obviously gone over a year for a while. And I'm trying not to think about it.
I am so proud of you.
Thank you.
And I know it's hard. Each and every day it is hard and, but you are conquering it every day.
Yes, ma'am.
Okay, so do you understand that you would have the right to an attorney?
Yes,
And do you understand an attorney is in a position where they go to law school, they practice law, they do these things, and they're able to understand the law, read the law, and they can negotiate with the state or argue and make arguments to the jury, such as defenses and those types of things?
I understand. I look at myself as more of an honorable person than that, and I like to speak for myself.
Appreciate that. Do you understand that not having an attorney, though, is the opposite of those things? Because they're not gonna be able to, you won't have the legal ability to be able to look and say, well, do I have a defense here? What can I argue? Is there any better deal I can get?
I understand.
Okay, now, do you understand you would have the right to a trial? You would have the right to have, you would have the right to testify on your own behalf or remain silent and not have your silence used against you. You'd be able to have that jury trial in which 12 of your peers would be able to listen to a trial and hear it, and they would need to make a unanimous decision as to whether or not you're guilty or not guilty. You would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
Do you understand that you're pleading guilty to the count of operating a motor vehicle while revoked? The state would have to prove on or around May 27th, 2024 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked, that you did operate a motor vehicle on a highway or roadway of this county during that revocation period or thereafter, and the revocation was a result of an OWI or similar offense.
Yes, I understand.
You understand that upon conviction, you could be fined up to $2,500 or not more than 1 year in the county jail or both.
Yes, ma'am, I understand.
You understand that there is an agreement here where the state has agreed to recommend to the court costs only, but I don't have to follow that if I think that this was serious enough. Do you understand that?
Yes, ma'am.
I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am.
Are you admitting here today you in fact did operate a motor vehicle on a highway or roadway of this county and state?
Yes, ma'am.
And are you admitting here today that you in fact, that your driving privileges were revoked and you knew they were revoked?
Yes, ma'am.
You have any questions for the court or for Mr. Schmidt before I proceed?
No.
Has anyone made any threats or any promises to you for you to plead guilty today?
No, ma'am.
Are you doing so freely and intelligently, telling me you fully understand what you're doing
Yes, ma'am.
and voluntarily?
Yes, ma'am.
Then I do find that you are competent and you are freely and able to represent yourself. And you're rightfully, knowingly, and intelligently waiving your right to an attorney and to a jury trial. As to operating while revoked, a misdemeanor, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the sole charge. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
Doing the cost is appropriate in this case. This defendant lost his license from an OWI from 2020. He's only had one prior OAR, and it was in 2021, so it's been a long time since then. The only warning I'd give him is if he waits too long, if you go 8 full years without a valid license, then you need to retake the written and field driving test again. So he would behoove himself to get his license back before 2028. That's all.
Okay. Mr. Naine, is there anything you want to tell me? Anything you want to let me know?
I'm trying. That's about it.
Make vast improvements.
His mom said he made vast improvements. I'm so proud of you. I really, truly am. And I hope you're proud of yourself because this is a big deal and it's a big step.
Yes, ma'am.
Taking control of your life and control of your path and control of the demon of alcohol. So I'm so proud of you with that.
Thank you.
And I think costs are appropriate. Instead of $500, which would be court cost, fees, and a fine, what I'm going to do is I'm only going to assess $300. I'm going to waive the rest. Okay, so then you're going to be able to get the remaining money back or to whomever posted it. And it looks like it's your mom, so she'll get it back in a week or two, probably. Again, I'm proud of you. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order you provide your DNA, okay? What you're gonna do when you're done is go to the jail just to make sure that they have it. They may already have it. But if they do have it, they'll just say, you're free to go. If they don't, they'll just quick do a swab. But make sure you do it and just check with them right after today. I said 20 days to appeal. I think that covers everything, Mr. Schmidt.
That's all for me.
Again, I'm so proud of you. We're
Thank you.
adjourned.
Is there any more hearings after this one?
We're done.
We're done.
We're done.
You need to grab anything or just go do the DNA?
He does, right? You have to grab a piece of paper, I think, and then go get your DNA, all right?
Good afternoon, Judge.
Good afternoon. Thank you for filling in today. And how do you say your last name?
It's Fondre.
Andre. Thank you so
Yes.
much.
Thank you.
We will go on the record in the matter 26 CF69, State of Wisconsin versus Shane Fagnan. The state appears through District Attorney Kevin Schmidt in person. Mr. Fagnan appears in person with his counsel, Kirk Anderson. We're set here today for a preliminary hearing. Mr. Anderson, is it proceeding as such?
Your Honor, he's going to waive, Your Honor.
Okay, so it's a waiver of a preliminary hearing. Mr. Fagnan, did your attorney go over with you what a preliminary hearing is?
Yes, he did.
And that the burden is on the state to prove a felony was probably committed by you in Burnett County?
Yes,
You understand that by waiving your right to a preliminary hearing, you are agreeing that at least the state can meet that burden?
yes,
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you. He'd be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. But for today's purposes, you're giving up that right?
Yes, Your Honor.
Do you understand that at a preliminary hearing, if the state does not meet its burden as to felonies or the level of the felony, I could reduce the charges or dismiss them altogether? Do you understand that you would be giving up that right?
Yes, Your Honor.
Do you understand that as a result of waiving your right to a preliminary hearing, it means that this matter will be bound over to future proceedings, which could include a trial?
Yes.
Do you understand that once you give up the right, it's forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes, Your Honor.
I will find that he's freely, intelligently, and voluntarily waiving his right to a preliminary hearing. The court will find probable cause and bind the matter over. Information, Mr. Schmidt,
I filed the information. It mirrors the criminal complaint.
would you like to proceed with an arraignment here today or set it for another date?
Your Honor, let's set up for another date so I can get discovery and we can have potential resolution discussions.
That is great. That is fine. I can set it for, if Mr. Fagnan's okay with it, if it does proceed in that fashion, and if you're okay with Mr. Anderson appearing by video conferencing, I would be fine with that. But in arraignment, you have the right to say, you know what, Judge, I want him here with me.
Yeah, I understand that.
Okay, so is it okay? Can he appear by video if
Yeah.
you would like? Okay. Sometimes when an attorneys are always busy, and sometimes it's easier for small little hearings to be able to do it by Zoom, but only if you're okay with that.
Yep.
All right. It's just an arraignment. So I could do it at 2 o'clock on July 22nd. It's an ADA week.
That I'm pretty full that entire day, Your Honor.
2 o'clock on July 23rd.
Got the 24th open?
I do not.
Okay. Following week, I'm much more available.
And I am not. I could do, so you're pretty busy all day on the 22nd, even around 10 in the morning?
Mm-hmm. Could you, I mean, on the 23rd, if we do it late morning, obviously it won't be a very long hearing.
No, it will not. I'm booked all the way, but I can look to see if there's a double booking. Wait. I can do 11:45
That works, Your Honor.
Which day?
on July 23rd.
Works for me.
And if it goes a little past noon, would you be okay with that, Mr. Anderson? Because I'm double booking you, but one of my cases ahead involves an interpreter, and you can't ever guarantee how smooth or how quick those hearings go.
Sure.
So
That's
I'm usually right on time, but I just want to have that out there. July 23rd, 11:45. We'll set it for the arraignment. Okay, Mr. Fagnan?
Yep.
All right. Thank you. Then we are adjourned.
Thank you, Your Honor.
All right, Kurt, have a good day.
See you next week.
We're off the record. Mr. Fagnan and Mr. Anderson, I'm not sure, but I think maybe on one of the documents, are you being revoked?
Yes.
Sent back? Okay. That just makes a lot of, it, affects this case.
Yep.
Just wondering. Okay, thank you.
I don't think so. I don't have emailed much times.
Nice to meet you. I don't recognize.
No, fine.
Judge, I'm gonna log out of this Zoom and join
that's
the
right.
other Zoom
Yep.
for the 1:15
Thank
hearing.
you. Thank you for reminding me. We will go on the record in the matter 13 CF 132, State of Wisconsin versus Zebedee Shadis. The state appears through Department of Corrections agent Gretchen Annabus in person. We have Mr. Shadis appearing in person without counsel. We're here for a probation review hearing. We were in court on a probation review hearing not too long ago on April 13th, 2026. The court did issue some directives and orders to Mr. Shadis as it relates to payment of restitution, etc. There remains outstanding restitution, at least of this court's knowledge to date, $481,308.72. The court did order that Mr. Shadis make payments, I believe, of at least $500 per month since the last hearing. Ms. Annabus, please update the court.
Mr. Shadis at this time has brought his amount down to $479,031.05. I have not received an updated budget worksheet. I was informed that there has been no changes. I did request him to fill one out. I did not receive one. He has made a payment in May, June, and July at a rate of $254. His agent was informed that that is not the minimum requirement. And on 7/6, there's a payment pending of $1,515.67. That is all the information I have for him.
All right, Mr. Shadis, why did you only make $250 a month payments? The court ordered you and directed you to make $500 a month and did tell you that if you do not, you will go to jail. Do you understand that?
I understand.
Okay, why did you only make $250 a month?
From my knowledge, that's all we could make.
From my knowledge, that's not your order. Your order was $500 a month or jail. $500 a month or jail. We have victims who are appearing here today who have appeared here at, I can't recall because I wasn't the judge on most of this, but I'm going to guess they've appeared at every hearing, or for the most part, all of the hearings, and they hear the same thing over and over again, how you burnt down their house, killed their dog, ruined the wedding, caused enormous stress and trauma upon this family to the extent of $481,000 some odd dollars, but that's not even the amount, the full amount. I'm sure there's a whole lot more that hasn't been accounted for, but that's what you were ordered to pay. And now, April 13th, the court ordered $500 a month, and you've not paid that. So is the $1,015 supposed to bring it current, Ms. Annabus?
I believe so, yes. That was just paid on the 6th, so last Monday.
So 6th on the last Monday. So a total of $1,765 and some odd cents has been paid to date. I can't recall if I ordered the first payment to be in April or not, or if it was May. You recall, Ms. Annabus?
I believe it was the following month.
So it could be May, June, and July. So, Mr. Shadis, it appears from the payment that's been made on Monday, it was to save your butt from jail because it caught you up on all of those months at $500. But I'm going to tell you that's not what the court ordered, and I'm ordering again $500 a month. And this starts in August because you're up to date May, June, July. At minimum $500 a month, not $250 one month and $250 a next month and $250 other month, and then $1,000 the other or right before the court. That's not going to cut it. $500 a month. I don't care if you're current and you've paid all of the money total, what you should have paid in all those months, $500 per month. That's the order, or jail. Do you understand that?
Yes.
So $500 a month. I'm finding you in contempt of the court's order and directive. Even still, you caught up, but that's not the court order. You're still in violation. So I'm going to order from here on out, starting in August, the $500 a month, not a penny less than $500 a month, or you will sit 20 days in jail. Do you understand?
Yes.
So I'm going to set another hearing date right now. And I'm going to say that's the least that you can do, the least that you can do. Even if you were able to come up with a check for $500,000 and pay it to the victims, that's not going to make them whole. That's not going to make all of this go away and their lives to feel better from the incident that occurred on August 16th, 2013. It's just not going to do it. So at the very minimum, you can make the court-ordered payments at this time, and you can do it monthly as ordered by the court. So I'm going to give you a few months to show me that you're going to do that. So you'll have August, September, and October to make your payments. I'm going to order that we have another hearing in person, 1 o'clock on November 3rd. 1 o'clock on November 3rd, okay? Do you understand the court's orders today?
Yeah.
And you understand what happens if you don't abide by the court's orders? And what is the court's order?
$500. Starting in August, September.
A month.
Yes, a month.
All right. What if you pay $499.99?
I know, not gonna cut it.
Not going to cut it. All right. So you do understand, you can comprehend, and so that is the court's order. So I will see you on November 3rd unless there's anything else that you want to discuss.
Nothing further.
Okay. So November 3rd, you can come up here, get your notice, and I will see you at 1 o'clock. We are adjourned. Mr. Wellman was out there, Mr. Shadis, but I don't see him now on the bench. 2:30. Oh, his is 2:30. I know he was here though. I did see him. All right. Well, I guess that didn't take as long as I thought. Ms. Burhouse, so we are off until.
What would you do if a judge offered you a second chance? Not with punishment, but with encouragement. This courtroom session wasn't filled with shouting or dramatic outbursts. Instead, it showed something just as powerful. A judge determined to help people turn their lives around while still holding them accountable. One of the first defendants appeared before the court after reaching a plea agreement in an operating while revoked case. Because he was already participating in an intoxicated driver intervention program, the judge worked with his schedule, even arranging a Friday afternoon sentencing so he could finish his work week before reporting to jail for the required weekend sentence. It was a reminder that accountability and compassion can exist at the same time. But the hearing took an even more emotional turn with another defendant, who had been struggling to get his driver's license back after an OWI-related revocation. He explained that life had changed dramatically. He had been forced to move, lost his job, and was trying to rebuild while dealing with the costs of getting his license restored. Instead of rushing to punish him, the judge carefully walked him through every option available. She even offered to redirect money already posted with the court toward the programs he needed to complete, if that would help him finally get back on the road legally. Then came the moment that changed the entire hearing. The defendant revealed that he had remained sober for more than a year. The judge immediately stopped to recognize the achievement.